All right, welcome back to the Law&Crime Network. My name is Bob Bianchi. I'll be with you at 3 o'clock this afternoon. Got great guests and great trials. Don't forget that we got this Grant Amato case coming up. It's a death penalty case. Killed his mom, allegedly, his dad, allegedly, and his brother, allegedly. And part of the motive in this case is that he stole $200,000 to do, of all things, well, pay for a cam girl out of Bulgaria. And that's the prosecution's theory as to why those three folks you see on your screen right there are dead and why he is on trial right now, at least part of the reason. We're covering the Rosenbaum case, too. We've got some great analysis here from both Ashley and Gene. It's really been a riveting case here, and the prosecution seems to be taking nick after nick after nick and piling on the evidence in their favor in what was originally a very contested case. Part of that case involved the ER doctor that treated Layla. Let's take a look. Well, guys, I mean, another compelling witness, Ashley. First of all, he's talking about all of the bruising that is going on in the child's body, the chest, the pelvis, the back, from top to bottom. Does a great job at indicating that these are not from resuscitative efforts, calling one of the fractures when he did that bone scan a nightstick fracture. They were in odd locations and not locations that are consistent with just an accident that a child gets into. Obviously, is going to be compelling testimony, not to mention the fact those jurors are seeing pictures we're not.
Right. And just to imagine, this ER doctor just testified to the fact that he's seen over 100,000 patients. For top to bottom bruising on a 2-year-old child to really stand out to him enough to cause him to do something out of the ordinary, which is to order a bone survey in this case to see if there's any latent fractures or any other injuries that are healing. And he's talking about a defensive wound on this little girl's arm. He's saying, like, look, I'll admit, little kids, fall down and they hit their head and they get bumps and bruises all the time. But you've got bruises top to bottom all over her back, defensive fractures, it looks like in this case. That's not normal. And for that to stand out to this experienced ER doctor says a lot about this case. Yeah, absolutely. Very good point, Gene. I was just wondering, and it's just, again, I don't know what the rules of evidence are there. Actually, we have an expert right here. But nevertheless, my question became, he's actually giving expert opinion. He's going beyond just the facts of what he did when he says, in his opinion, these were not resuscitative efforts. Rather, they were blunt force trauma injuries. But nevertheless, compelling testimony. I don't see a big problem with that evidentially, do you?
Well, no. If they noticed him up as an expert, there absolutely is no problem. But even if they did not, it's based on his training experience. I don't know if he said 100,000. I thought he said 100, but he's seen a lot of darn patients. So based on his experience, he can make conclusions. Yeah, and I agree with Ashley. After seeing 100,000, that's the number that he gave. The fact that he would have this bone survey done confirms to the jury when the prosecutor says this experienced doctor felt that it was so suspicious that he went and had this test done, really is very, very good for the prosecution. And he's not the only medical professional that testified in the case. There was an ER nurse that did as well. Let's take a listen. All right, so Ashley, the importance of this time, she explains the mechanism of injuries and how that occurs. I think the ER doc was obviously a very powerful, witness, but what is she lending to the prosecution here? I think really all she's doing is kind of backing up. I mean, I don't want to say bolstering because, then maybe we'd have some objections there, but she's backing up everything that the ER doctor said in this case. And I think what she's doing is she's kind of putting it in context and for the jury to have something to lean on if they're, a little worried about the ER doctor's testimony. Right. Sometimes when you get doctors in there, you get jurors falling asleep and you get them not paying attention anymore. Science sort of goes over their head. You've got a nurse, she's a little bit more relatable. She's breaking it down in layman's terms. Yeah, excellent analysis. And by the way, you told me when we were on break that Georgia has adopted the federal rules in terms of the evidential rules? The Georgia rules of evidence are almost identical to the federal rules of evidence. So as long as they qualify the ER doctor as an expert in this case, which I'm sure that they did, and we just didn't watch it because it's very boring and it was off screen, they should be good to go in his testimony. Gene, talk to me a little bit based on your experience about kind of what Ashley is alluding to, that is redundancy with witnesses and how you got to be careful, but by the same token, it can be very good to support and back up one another, but you don't want to put too many witnesses on to say the same thing because you get that blown in your face too. I'm glad Ashley mentioned the federal rules of evidence. Rule 403 is the famous unduly prejudicial rule. And you can keep things out you can keep out evidence that is relevant if it's cumulative. Right. And if you called a third witness in addition to this nurse and ER doctor, then I would object that it's cumulative. They've heard enough. it corroborates, the second witness corroborates the first, but then the third or fourth witness would be, too much, as they say, cumulative.
So, Gene, evidence that's relevant may be excluded if it would create undue confusion with the jury, or if it would be cumulative. I mean, it's not just cumulative. There's a number of different reasons under 403. Yeah. Sometimes, the one I've always found interesting, at least in Jersey, is if the prejudicial effect outweighs its probative value, which requires the court to go into a balancing decision as to whether that could be excluded. So, I mean, have you ever had one of those where I've had cases where the judge is like, it's really, really relevant, but I'm banning it under evidence rule 403 because I think it could lead to undue confusion with the jury. And I'm like, wow.
Exactly. How can relevant evidence ever be confusing to the jury? But I agree. I have had cases where this has come up. Obviously, it's a pretrial argument that you make, or you do it outside of the presence of the jury once the objection has been made. And sometimes when, as a defense attorney, you got some real bad facts, you don't want the prosecution throwing up witness 1, 2, 3, and 4 that are all saying the same thing. And that's all the jury's going to remember, because jurors remember what they hear repeatedly.
Yes.
Just like we do in advertising.
When you're a defense lawyer, you take out that 403 flag and you throw it. Judge, please save us here. We need a break. We've had too much of this compelling evidence that's been killing us.
Exactly.
Okay, guys, listen, great to have these guys analyzing this case. They're the best. We're going to take a quick break, and we'll be back on the other end. Stick with us. Okay, so Ashley, what are your thoughts on the first statement that Jennifer is making is being recounted by this officer? What's the prosecution trying to prove here?
Okay, I think the prosecution is trying to show that Jennifer is talking to the police in this case, and that if this is a concocted story, maybe she thinks she's a little bit smarter than they are, and she's trying to explain away that bruising that the ER doctor testified that he saw all over little Layla's body by saying that happened with the CPR. I hit her on the back, I put the butter knife down her throat. I was trying all that sort of stuff. So, you've got this fine line that you walk. Is she telling it? Is she innocent and she's telling this story to the police because that's what actually happened? Or does she think she's a little bit smarter than everybody else and thinks, oh my goodness, I need to explain away these bruises that are already there?
Right, Gene, to Ashley's point, my point is that they always feel they have to talk because you don't want to look suspicious. But the other one is, gosh, how many times have we convicted people based upon what they gave to us as statements that we never would have been able to prove the case if they didn't give us a statement? And why? Because they suffered from thinking that they were the smartest guy or the smartest girl in the room.
Oh, self-serving statements, false exculpatories, are priceless. But I got to compliment the defense attorneys a little bit. I now see why they didn't object when the social worker, Ann McCullough, was on the stand and Millie was saying that mom put a knife down her throat, because that's where that came, the butter knife.
Yeah, for sure. Okay, excellent point, Gene. Also in that emergency room, if you can imagine, we had an ER doc, we had a nurse, we have this police officer, was also a foster care worker for the children that was in the ER, that was actually listening to the information that Jennifer was giving to the police. Let's take a listen. All right, Gene, Rossie, I got to get my Bianchi up here, okay? I'm listening to this testimony, and here's this awesome witness for dad, the awesome witness for the husband, that says she's watching this in the demeanor of Jennifer. She doesn't know why she can't cry, Jennifer. But the husband was very distraught. He was upset. And then the husband wasn't there, he indicates. He was in the care and custody of Jennifer. These are all extraordinarily defensible points for the defendant, the husband, that cannot be brought out if you're going to properly represent Jennifer. Gene, Rossie, I'm sorry to keep bringing it up, but it's even worse now.
I need a bowl of polenta to calm me down. Okay? But no, on a serious note, I am absolutely livid, Bob. Ashley, too. I am livid. This is a total disgrace, because that husband has a defense. I mean, this witness is fabulous for the husband and horrible for Jennifer, the wife. She can't cry because I have no more tears. Baloney. Her tear ducts are full. They were never used. She was stoic. The reason she's stoic, because it wasn't a surprise that the child is dead. And this is my favorite. When the husband was talking to the investigator, Jennifer was interjecting.
Yeah. Ashley, Gene Rossie has a way. He brought up two foods in one comment. He went to bologna and polenta. He went from the great, polenta to bologna, whatever.
Right.
But seriously, I want you to put your thinking cap on for me. I know this is really hard. Thread this needle for me now. If you're defending both of these people now, what do you do? Do you get up there and say that if it's her, he didn't know about it? Can you still say that?
This is just unbelievable to me, especially with this witness. I mean, the defense attorney had to know that this witness's testimony was coming and what she was going to say. I can't imagine what their argument is going to be now. I mean, sure, you can get up there. I mean, there's nothing precluding you from getting up and closing argument saying, look, if you do find her guilty, then, you know, say he wasn't there. But I think then you're throwing Jennifer under the bus. You can't do that. You can't split the baby, throw the baby out with the bathwater.
Right. If I were representing, I want to be going that she did it as the lawyer, and he had no idea he's as much of a victim as she was. Excellent points, though. Listen, you know, one thing that's really important is where is this evidence of choking that went on here? We had an ER nurse that testified in the case. Let's take a listen. Okay, Ashley, I mean, pretty compelling testimony. There was an objection by the defense at some point, I think because they used the qualifying language of an expert, but nevertheless, the prosecutor got out. In your experience, as opposed to in your opinion, have you seen a choking-related incident with a person that doesn't have petechia, they call it bloodshot, eyes? They were not cyanotic or blue in color, they were pale. So a pretty powerful witness for the prosecution. Yeah,
basically she's saying there's nothing here that's consistent with the choking story. And I'm actually surprised, you know, with the defense, they made that objection, but the only thing that they seem to be able to achieve was to have the prosecutor ask the question again, saying, you know, hey, in your experience, is this consistent with someone choking basically on a chicken nugget? She says no again. I think, you know, they kind of hammered it home for the jury. Got a second chance at a second bite of the apple on that.
Yeah, Gene, I noticed that too. She used the expert language, and the judge sustained the objection, and they said, in your experience, and she gave her opinion anyway. And what's irrelevant is the opinion. But nevertheless, this nurse also said there was no evidence, physical evidence of anything. She had a clean airway, I think was a term that she used. It wasn't a dirty airway. Pretty compelling witness.
Oh, I think Miss Espinosa is one of the best so far. Absolutely.
Yeah, so, you know, guys, just thoughts real quick on, we're going to be taking a break right now, but I want you to think about what we're, on the other end, what can the defense do right now based upon this cascading set of data that's coming out to the jury? And the question is, that have been asked already in this case, do you advise the defendant to take the stand after all this? But you have to wait to listen to that answer, because we're going to do a break. We're going to come back on the other end with more Ashley and more Gene. Okay, so Ashley, again, this is direct examination. This prosecutor is taking his time and asking these questions, and she just keeps delivering the home run hits here. The injuries all over the face, the varying wounds, and her precision with regard to the fact that they did not occur, many of those wounds, on the day of the incident, but were from previous instances, because I could tell by the coloration and the manner in which the wound was healing. And I loved, she's really good with the jury when she explains, just like when you get, you know, a cut and then you have a scab and it turns brown and the white edges and all that. What'd you think? Right.
I think she's very descriptive, and she's setting up a great closing argument for the prosecution. You know, this is a pattern of abuse. These wounds were healing, and I mean, the one slam dunk that she said was, hey, these absolutely did not occur on the date of death, so they were there previously. They were in the pattern of healing. And, you know, prosecution's taking a big risk right now. This is post-lunch. They've dimmed the lights to show some slides. You know, this is nap time for the jury. So if you didn't have Dr. Darisaw on the stand, I think you'd be really risking something here.
Yeah, Gene, I love it, because it's, you know, look, this is a real practical response that Ashley just gave. You know, they're full, their bellies are filled, the lights go down. You got a doctor on the stand, Gene Rossie. It could get like a little bit into that lull of what just happened, but I don't think so with this witness, because I think she just delivers so well. Yeah,
she has a great disposition and a good demeanor. And the thing the one complaint I always have about experts is they have to realize that the whole world is not just watching them. The whole case does not evolve around them. And they get up there and they act a little too uppity for their own good. She doesn't do that.
Yeah, very good point. And you know what, Gene? It is that uppityness, which is where on cross-examination, which I think is my best crosses are with expert witnesses, I get under that skin and pick at that scab that they have, where they think that they are the sole witnesses of the universe. Definitely a lot of haughty expert witnesses out there. Guys, we're going to do a little work here at the Law&Crime Network. We're going to take a break, and we'll be back with more Law and Crime. Okay, Ashley, I mean, this is really an extensive examination, direct examination, and she's doing a great job of just detailing so many injuries. I'm looking in the chat room, and they're like, poor thing, beaten every day. That's at least what our second jury is coming up with in their thoughts and listening to this testimony. What do you think?
I couldn't agree more. I mean, basically what she's describing is a pattern of abuse. You know, she's saying that these injuries not only were all healing at different rates, they definitely couldn't have been, she didn't get the injuries on the day of her death. And each injury, each abrasion is healing on a different timeline. So clearly she's getting these getting injuries consistently, and they're healing at different rates. So I think that's going to be the main part of her testimony that we're going to take away.
Yeah, Gene, and I think very powerful, testimony, especially when you couple it with the injuries that were on the other daughter, just really painting a horrible picture of these two kids' lives.
Oh, absolutely. I want to go to something you gave us during the break, the homework. You know, how you defend this.
Yeah.
And I got to tell you this. I would not call the wife. I would call the husband. And I call the husband for two reasons. One, I think he's got a defense. And number two, he could possibly help his wife by saying, I observed her when I left that day. Layla was sleeping. She tried to treat the daughter well. Something to help the wife. So calling the husband would be a possible twofer to help himself and also to help the wife, mitigate what appears to be a mother who's just out of control.
Yeah, Gene, thank you for answering that. I just think it's dangerous for the husband, in my opinion, to get up there, because as a defense lawyer, I want to be hammering. You didn't hear anything that connects him to knowing anything about this. She fooled everyone else. She fooled him. But, being forced to do that because one lawyer is representing two defendants is problematic in my mind. We're going to go to break. We'll be right back.